Chairwoman Click, and committee members. My name is Bobby Schindler. I'm the president of the Terri Schiavo Life and Hope Network, and I'm here on behalf of myself. Thank you for allowing me the opportunity to provide testimony in support of HB 2606 to repeal the Texas Advance Directives Act. The Terri Schiavo Life and Hope Network serves as a voice for persons with disabilities established in response to the death of my sister, Terri Schiavo, a cognitively disabled woman who was intentionally dehydrated to death by court order against the wishes of her family. The Life and Hope Network has advocated for thousands of patients who are facing the prospect of the denial or withdrawal of care. The 10-day rule of the Texas Advance Directives Act allows a hospital to unilaterally authorize the withdrawal or withholding of a patient's life-sustaining treatment that is not based on medical determinations, but rather value judgments focused on the patient's quality of life. Effectively, this law permits patients to have their lives ended without due process of law. Moreover, it leaves the onus to transfer the patients from the hospital, imposing the decision to withdraw or withhold treatment on those individuals advocating for the patient. This past July, the Texas Second Court of Appeals wrote about the case of Tinsley Lewis, who fell victim of the 10-day rule. Quote, when a terminal ill patient or her surrogate decision maker, especially a parent of a minor patient with her own individual liberty interest, actively opposes the withdrawal or life-sustaining treatment, the right to life is clearly implicated, end of quote. While the final legal outcome of the case has not been decided, the court's ruling is significant for future victims and their families of the 10-day rule. In my nonprofit work as a patient advocate for over 15 years, we receive regular calls from families in crisis who are confronted with exactly these types of scenarios. Sadly, it's become alarmingly evident that our healthcare system is now incentivized to impose death upon vulnerable patients, and the powers of laws and medicine have become weapons rather than shields. Families are the protectors of life, and healthcare is about what is best for the patients. Many patients have the capability to recover after 10 days, and it is not in the best interest of patients to put arbitrary limit of when someone just needs time to recover. For example, JAMA Neurology recently published their findings that patients who experience a moderate or severe traumatic brain injury and lose consciousness nearly half regain functional independence. Robert Kowalski, MD, MS, Department of Neurology, University of Colorado School of Medicine, remarked about the significance of this study and urged caution when deciding to withdraw or hold care to those with serious brain injuries. Similarly, a new study published by the University of Kentucky on hyperbaric oxygen therapy shows that this treatment exhibits significant promise for the brain injured. This is important for many reasons, but primarily because there are no current FDA-approved treatments for TBI. If HBO can be FDA-approved, it could afford a much-needed therapy for brain injury that is currently unavailable. It is the promise of brain injury research that underscores the concerns opponents have about these types of laws that undermine the dignity and the rights of the medically vulnerable patients to receive care, especially in situations where hospitals are given sole authority to override medical decisions explicitly expressed by patients and the families advocating for them. No other state has laws that violate the patient's right to life and places a stain on the constitutional right to due process. Texas needs to adopt comprehensive reform in the 10-day rule to protect patients' rights, restore patient autonomy, and create an even playing field so that these critical medical decisions are not left in the hands of strangers. In summary, no other state has laws as egregious as Texas laws, which violate the patient's right to life and constitutional right to due process. Therefore, I respectfully urge a vote in favor of HB 2609.